now.
Sure. Hello, everyone. Good afternoon, good evening, and wishing you all again a very happy Independence Day. So, on this momentous occasion, on behalf of the ASSOCHAM IPR Council, I am Hemang Shah. I'm the co-chair for the National ASSOCHAM IPR Council. So, we welcome you on this webinar on the registration procedure for trademarks. Today, we are joined by very dear colleague of ours, Harsh Pangi, who will be conveying the remarks. We also have a team from Qualcomm, apart from myself, my colleague Anirban Mukherjee is there, and also from the ASSOCHAM team, have been doing a fabulous work, with the outreach and the arrangement of such webinars for website. Now, today's material is also, before we dive into what Harsh is saying, I just thought of sharing the a few slides on one of the course materials, which will be like a ready reference, for all startups, SMEs, individuals alike. This is called L2PRO India, and it's a program that we have been deeply affiliated with. Now, I'll just switch over to my hat where I work with startups as a part of Qualcomm's various programs in working with startups. So there, one of the observations that we saw was that the IP awareness would vary from one startup to another. And what used to happen is that at sessions like these, when you are interacting with IP professionals like Harsh, you will of course get all your questions answered. What would tend to happen is that the innovation happens in your everyday life, and that's where ready reference material was really not present over. So this observation was related to DPIIT, and along with them and National Law University Delhi, L2PRO was formed. And L2PRO stands for Learn to Protect, Secure, and Maximize Your Inventions. It's a program, a completely free e-learning material to help, with the awareness, across various factors, such as how can you protect your innovations with patents, how can you develop trademarks, and see like some of those, real life examples that how you can integrate IP considerations into business models, basically get more value from your intellectual property and your innovations. The course is split across 3 different levels: basic, intermediate, advanced. Now, at the basic level, this would be material that is suitable for everyone, like everyone, especially at whether you're a university professional in academia, or whether you are a startup or a small and medium enterprise. I highly recommend that everyone go through at least the basic level. And then if you have further interest, you dive into the intermediate level, which goes into things such as how you do IP searches, what does the filing and acquisition look like. So today's session would be partially covered in this lesson 5 out here in the intermediate module of L2P. And then if you're further interested in the deeper nuances of intellectual property, you dive into the advanced level module. You can go at the course. Sorry, I just saw a comment on the mic. Is my audio level okay? Is it coming muffled? Anirban, you're on mute. Sorry.
Hemang, it's coming a little muffled. Maybe if you are a little louder, you could come. Yeah.
I'll do that. So let me move it around, and hopefully, is it a bit better now?
Yeah, it's better.
A little bit. I'm sorry about that. So there are 3 different modules for L2PRO: basic, intermediate, and advanced. I highly recommend everyone to go through the basic level, and then if your interest is there further, which I'm sure it will, you dive into the intermediate level. And as an example, today's session of how you register for trademarks is covered in lesson 5 of the intermediate module of L2PRO. And then you have the deeper nuances of intellectual property rights, which are covered in the advanced level. The course can be accessed at the website, which is the l2proindia.com domain, or you can search for it on your app store. Just on your phone, just as you search for apps, type L2PRO India. Now, because this course has been written for startups and SMEs, and it's also meant like a ready reference material, the information is also presented in such a manner, things which are easy to find. So, for example, here in this screenshot, we are showing you some resources, such as where can you find the list of patent and trademark facilitators that are brought to you as a part of the SIPP, the Startup Intellectual Property Policy. There are some pop-up questions which test your understanding along the way. With every lesson, there's a 2-minute intro and a 2-minute summary video. So in my opinion, within 5 minutes, you can gain about 70% of all the material in a particular lesson. And if you of course want to spend more time, you can go through each and every section of the course. And there is an assessment at the end of each module. So at the end of basic, intermediate, and advanced, there is an assessment. It's a multiple choice question, but it's also based on a case study. So you will be answering questions which are given to you that here's a situation that a typical startup is going to encounter, and what would you do in such a situation? You already saw the introductory video for the course. I will not play it here. And my colleague Anirban has pasted the links for you in the chat box, so please take a look at that. And that's really what we had for L2PRO. Please take it, download it. Let us know what your feedback is, and we'll be happy to take any questions, any comments on that along the way. Now we'll switch gears and turn our attention over to today's program. And let me first start by introducing our speaker, a good friend of mine, Harsh Pangi. Harsh is building a purpose-driven brand, IP5, which is an IP consulting firm operational from Belgaum and Bangalore, India. He has a diverse professional experience of 17 plus years, working in the field of engineering and technology with companies like Infosys, Tata Elxsi, and in the field of IP with SAP Labs India Private Limited. Harsh is an innovation coach with the Institute of Inspiring Innovation in Bangalore. He is a mentor and advisor with various startup accelerators and incubation centers across the country. Harsh is registered to practice as a patent agent with the Intellectual Property Office India, and he holds a Master of Science degree from Syracuse University, New York. Harsh, thank you so much for joining us today, and we look forward to your enlightening webinar on how we register trademarks in India.
Thank you, Hemang. Thank you for the opportunity, L2PRO as well as ASSOCHAM. The reason I have kept in my introduction as I'm building a purpose-driven brand is the purpose is to spread awareness, IP awareness, which is quite lacking in the startup ecosystem. So I have been working actively with the startup ecosystem over the last couple of years, and I see that people, some of the startups are matured. They have gone through the processes. They have filed multiple IPs and they understand the process in a better way. While there is other side of the spectrum where there's always confusion between what type of IP has to be filed, whether one needs to register the IP or registration is not mandatory. So today's topic is about your brand, how you build your brand, how you want to protect your brand, and how you want to grow, how you want to be identified as a brand. Right? So I'll share the screen, and can someone confirm if the slides are visible?
Yeah, it is visible, Harsh. Harsh, your voice is coming a little muffled. Is there a way you could improve, your voice?
Is this better? Come a little closer to the mic.
Sure.
Okay. I'll probably keep my video off for some through the presentation. I can turn it on towards the end. Maybe that can help. All right. Yeah, so today's session is about registration procedure of trademarks in India. So we'll begin the presentation with defining what intellectual property is, and then do a deep dive into the trademarks. So anything that your mind is able to think or conceive, right, is referred to as intellectual property. So since your mind is able to conceive different types of thoughts, right, different types of creations, there are different types of intellectual property to protect each type of creation. So understanding this very basic thing is very, very important, because one type of IP is not a substitute for other type. So for example, if you want to protect a technical solution, you will need to file a patent. You cannot file a copyright for it. So each type of creation that your mind is able to conceive, right, can be protected by a specific type of intellectual property. And once you procure a right for it, it becomes a intellectual property right. So let's begin with discussing what trademarks are. So let's first define what trademarks are, and then do a deep dive understanding of the processes and different options you have to protect your brand. So any symbol or expression or name, right, that uniquely identifies your service or your product or your brand, the name of the company, is referred to as a trademark, right? So one very common confusion or common query that I keep getting from startups is registration mandatory? And if you want to protect your brand and enforce your rights, then the answer to that question is yes. For you to have some kind of judicial recognition or validity in the courts, registration is mandatory, right? So you can use the symbol TM once you begin with the trademark registration process, and once the examination process is completed, and on merits, if your trademark is granted, you could use the symbol R with a circle. So I have also come across instances where people use the symbol with TM with a circle. So that does not have any recognition. It does not have any value. So if you begin a trademark application process, you can use the symbol TM, and once it is granted on merit, you could use the symbol R with a circle. So please don't use the symbol TM with a circle, because it has no meaning at all, right? So having defined what a trademark is and how you represent, let's understand a few basics related to trademarks. So like any other type of intellectual property, even trademark is restricted to a specific jurisdiction or a territory. So what does that mean? So one, if you register or try to protect a brand in a specific country, in a specific region, it is you will get protection only in that specific country. And when I say region, it is restricted to the country. It is not extended to a continent. It is not extended to a let's say covering more than one country, right? So please be very mindful about this. Like any other type of IP, this again trademark, the rights are restricted to where they are filed. So trademark is a type of intellectual property that protects a brand name. So it can be goods or services, and there are 45 goods and services that have been classified and defined by WIPO, which is the World Intellectual Property Organization. So based on the nature of your product or your service or your good, one needs to identify if your product description or service description or company description would fit into one or more classes. So this is the most important step while filing the trademark. So I see a lot of people make this mistake. They end up registering in a wrong class, and subsequently they realize that they'll not be able to enforce their rights the way they should, and they try to find remedial measures. So I'll cover all these aspects as we move through the presentation. So the term of the trademark is it is valid for 10 years from the date of registration, and it is renewable perpetually. So this is very, very important. So like any other type of intellectual property, trademark also comes with a limited term, which is for 10 years from the date of filing the application. So every 10 years, you can pay the renewal fee and keep renewing your or extending your rights perpetually. Procedure timelines, it depends on a case-to-case basis. The reason I say it depends on a case-to-case basis is because depending on how unique your brand name is, the procedure timelines can vary, right? So continuing our discussion on trademarks. So generally it is advised that whatever you choose, right, your symbol, your expression, or your name should be unique and distinct, right? It should not be a dictionary word or very well known word, and it shouldn't have too many words. So when you are trying to use a expression, that expression should not be descriptive in nature. It shouldn't be like a sentence of, let's say, 4 or 5 words, or maybe more than that. The shorter, the better, and if it is not descriptive, it will serve the purpose of being identified as a unique brand, right? Some of the terms or expressions to avoid are adjectives, right? I'm sure people are familiar what adjectives are, and other examples include name of a person or place. So don't try to have a brand name that is associated with a well-known person or a name of a person or a place. Something that is related to religion or has some religious or sentimental values. Even such marks are not allowed. And something which is very commonly known, right? So you cannot use something that is very, very well known. Let's say, for example, Nike, Ola, right? Or Uber, and you may try to justify saying that they are not in the same line of business as we are, and try to use the same name and create a brand for your product or service. So you should typically avoid that. Okay. So in India, can file different types of marks. The primary one being word, and the second one is symbols or logos, right? So word can be like only a single word or a combination of words, or expression of 2 or more words. But again, please be mindful that it cannot be descriptive in nature. It cannot have like 4 or 5 words, or be a very long sentence. Second type is symbols and logos. Yeah, these I think people are familiar. Again, when it comes to symbols and logos, the symbols and logos have to be unique. This is very, very important. You cannot just take somebody's logo and modify it, or change the color, and change the stylistic aspects, and then try to create a brand out of it. Third type of mark is a shape, which is referred to as a trade dress. Right? So shape of a bottle or packaging material that you use, those can be trademark. Right? Fourth type of mark that you could get registrations for are what is known as collective. So it's linked to, if something is linked to a specific group, let's say a society or association, so you could have a collective mark under that, right? The next one is a series mark. So series are related products. So best example would be, let's say, the products that are sold by McDonald's. They have different sub products with different names. So all that could be filed as a series mark, where it would be like a continuation of continuation of the product line, indicating that it is a part of a series, right? The last type is a certification. Certification is restricted to authorities which are authorized by government. So FSSAI is one such example, right? So the typical trademark procedure in India is here. It's outlined in the slide. So I've picked up this picture from the trademark website. So typical process is you come up with a description of your product or service or goods, right? So once you have that, we will identify the classes in which your trademark has to be registered. So before even we begin with the process of registration, getting a professional search is recommended because as we learned in the definition of the trademark, any name that is unique, right? Name or expression or symbol, which can be a logo, it should be unique, right? Not something related to or something similar to what is already existing out there. So getting a search would be recommended just to understand the roadblocks that you may hit during the examination process and probably subsequent to the examination process as well, because trademark is one type of IP in which even if the trademark office grants or accepts your application, they open it up for inspection to the public, and any public who may find it is detrimental to their business or their brand, they may file a opposition. So I'll come to that as we move forward with the filing process. So once we have identified the goods and service classification, an application is prepared and filed with the trademark office. So typical processes, an application number would be allotted that is generated automatically when we file the trademark application. At the back end, there are some procedural things that are completed by the trademark office, and it is assigned to a examiner for examination. So typical examination process is the examiner would look for various combinations, right? If let's say you filed a word mark, so they will search not only for that word, but similar sounding words phonetically. If you change the spelling, let's say you're using Ola as Eula, right? You just change O to U. So it is identical, it is similar. Phonetically, it may sound similar to an existing brand. So they will check all those possibilities, combinations, and then they will issue a examination report. If they find anything that is worth objecting, let's say if it is not very unique, they will object it and issue an examination report with certain sections cited and the reasons for objections, right? So let's assume that whatever you have filed, is very unique, and it gets through the examination process. It is not objected. So acceptance would be sent from the trademark office, and your brand or brand which constitutes a symbol or logo or a name, right, or expression would be advertised in the journal. So for 4 months, once it's accepted, it is advertised for 4 months in the journal, and it is open for inspection for the public. So anyone who may find the brand is detrimental to their business, or sounds similar to their brand, or feels that it may create a confusion, right, they may file an opposition. So once an opposition is filed, the trademark office again evaluates whether the opposition is valid or not. You cannot generally file saying that this, if you file something that is unrelated, the trademark office will not entertain it. They will just reject your opposition. But if they file, if they feel that it is appropriate, then the opposition may be allowed, right? Let's say once you publish in the journal, there is no opposition filed, right? Then after 4 months, the trademark office will issue you a registration certificate, right? And once that is done, you have to keep renewing your trademark every 10 years from the date of filing the application. So coming back to the step of opposition, let's say if somebody files an opposition, they would check if the opposition is valid, and then there would be another round of examination and review, right? So there will be multiple rounds of hearings where you will need to provide justification why you think your brand is unique and why the opposition is not justified. So this image is fairly old. It has not been updated. Earlier, there used to be an intellectual property appellate board, which no longer exists. So even after the review and hearing, if you are not satisfied with the decision, you could go to the appellate board and appeal. But now, since the appellate board does not exist, you can move to the High Court. So the IP bench has been established in Delhi High Court, and you can go and appeal there. And they will look at the case based on the evidences that you have submitted, and on merit, whether they will decide whether it should be allowed or not. Now, in the slides that was talking about basics, I did mention that the timeline, procedure timeline, varies on a case-to-case basis, right? That is because, let's say, if you file an application, it is very unique, it gets accepted, it can go through as early as 2 to 3 months, right? So within 3 months of filing the trademark application, if it gets accepted by the trademark office, it would be allowed and then published, advertised for another 4 months, and if there is no opposition, you'll get a registration certificate at the end of 8th or 9th month. But if there is an objection, or if there is an opposition, right, the process becomes unpredictable. It can go anywhere between 12 to 36 months, depending on how many rounds of hearing happen, how many rounds of opposition happen. So all of that cumulatively adds up to the time. So effectively, you can expect the trademark to be granted anywhere between 3 months to 3 years. So that is the typical timeline that we have seen or experienced. So some of the pitfalls, I briefly touched upon this initially. Registration in the wrong class. So this is a typical pitfall that most startups fall into, because one, either they do not provide the right description of their product or business or service, or they do provide the information, and whoever is accountable to file, or whoever is filing your application, is not diligent enough to identify all the classes and the subclass definitions, right? So this is very, very common. Once you file the application, you cannot add any classes or subclasses to it. You can make a new application. However, your prior filed trademark application can become a reference or prior art to your new filed application. So if you file with incomplete subclasses or subclass definitions, you cannot add to it. You have to initiate a new, you'll have to file a new application, and again, you will end up in the same situation where your prior filed application would be cited against your current filed application. So please be mindful about this. Please be very careful, because once you register it in the wrong class, you cannot undo it. You'll have to initiate a fresh application, and only hope and pray that the subsequent process is fairly simple, and the examiner will be reasonable and will buy what you're trying to sell, and register the trademark, right? So coming to the myths, same or similar in a different category. So this is one common query I keep receiving all the time with respect to trademarks. So let's take an example of Nike or Ola. Now Nike is into manufacturing footwear and apparels, right? Now you say that I want to start a company with a brand name Nike, and I am into manufacturing electric vehicles. Is that possible? And the answer to that is no. You can do it, but then presuming Nike owns the brand, they have filed trademarks, and it's a very well-known trademark. Definitely there will be a legal suit against you. So likewise, so these are very well-known ones. I have only picked up the very well-known ones. Let's say even the brand is not very well-known, right? But then there is an identical brand already there in the market, which is doing business in a different category. So whether can I file a trademark application? The answer to that is yes, you can file. No one will stop you from filing the application. But then if you were to take my suggestion or my advice, I would advise against filing it, right? Although it's in a different category, it would be objected by the trademark office. However, in the past, there have been case laws where you can go and present saying that it may be a similar brand, or similar looking name, or a similar sounding name, but it is in a different category of business and all that. Some trademark examiners may accept it, some may not, right? Let's say best case scenario that the trademark examiner is able to accept what you're selling, right? And they allow the registration of the trademark. Subsequently, it will be advertised and open for opposition. So the original trademark holder has all the rights to file an opposition. So you'll have to go through an opposition proceeding, and opposition proceedings are generally very tightly observed. They will look at all the merits of the case. They will look at the brand or the mark from different angles. Like one of them that has been already listed, whether it is deceptively similar, whether it will create a confusion among common public. So all those criteria will be applied and evaluated, and based on the merit, it would be decided whether to proceed with the registration or not. So my sincere request and advice is, please try to have a brand name that is unique, right? You may like a name you may go ahead with registering a company by that name, okay? And your brand name and your company names may not be related. There is no mandate for that, right? So there are many companies which operate like that, right? Paytm is one such example, right? It's not Paytm India, it's 197 Communications Private Limited. So the parent company is 197 Communications Private Limited, and the products that they offer in terms of digital wallet or digital money is under the brand Paytm. So likewise, you could have a different name of the company and your brand. And let's say if you're providing services or building products in different categories under the same parent company, you could hold different brands. You could file different applications and hold different brands and have authority to those brands, right? So second one is cost is restricted to filing only. So this is not true. Like you saw, the process can become complicated if it goes through an objection. So one needs to respond to the objection. So there will be a cost involved at that stage. And presuming it ends, in one round, one iteration, the cost would be restricted there, or it could go to a hearing. If it goes to a hearing, then there would be a cost associated at that stage. Let's presume that after objection and hearing, your trademark is registered and advertised. If there is an opposition, again, there will be a cost involved at that stage. And once you start with the opposition proceedings, you can decide whether you want to pursue it or leave it. If you leave it, your trademark application gets abandoned. You will not be able to revive it. But if you decide to proceed, then you will have to go through the process, and there will be multiple rounds where you need to submit evidences, where you need to file a reply to the oppositions raised by the other party, and also there will be subsequent hearings that one needs to attend. So all of that would add up to the cost, right? Copying or modifying existing trademarks, deceptively similar. So this again is advised not to be done, because if something is there that's already registered, something is there that is already well known, please don't just try to change the syllables or vowels in that specific word or brand and try to come up with the identical brand or deceptively similar brand. You will not be able to get protection. You will not be able to exercise your rights. The last one is I can wait. So this is something that is common with a lot of startups and applicable to most type of IPs, mainly trademarks and patents in my experience. Just to delay the IP expenditure costs, people try to wait and see if they can be commercially successful or be able to attract some kind of funding, and then they decide to register their IP. It may work, but then if there is a competitor who is better positioned and better funded or has the cash flow to go ahead and register their brand before you, definitely there will be you will lose the market. You lose your brand identity in the market. So any type of IP, it's all about who registers first. So whoever files first is able to secure the right. So waiting is not advisable every time. So some of the do's, best practice is to seek protection as soon as possible. Try to have NDAs. This again comes around trade secrets or patents. So if you're discussing a solution, a technical solution that your company is developing or your firm is developing, always try to do that under NDAs. Seek value over cost, professional expertise. So I just briefly touched upon the pitfalls. What happens if you're trying to cut costs, right? You may end up registering the trademark for your brand, but if it is registered in the wrong class, you will not be able to enforce your rights, right? So identify your IP assets before it's too late. So this is again one common mistake that most startups do. They know, or either they know or they are not aware that something qualifies as an IP or does not qualify as an IP. Everything is there in front of them, but then they either overlook or are not able to identify or determine what qualifies as a trade secret, what qualifies as a patent, whether I should register the brand or whether I should wait and try building the product and use a different brand. So all those permutations, combinations, try to have clarity on that and try to seek protection as soon as it's possible. So have a strategy to build an IP portfolio. This is very, very important. It's not only related to trademarks, but any other type of IP, right? Be it patents, trade secrets, what qualifies as a trade secret, whether you can keep it as a trade secret or not. You need to make these decisions, you need to make these determinations and take a call on how you want to build your IP portfolio. Some of the don't false claim without filing. Don't try to use the symbol TM or R because it can attract fine and or imprisonment. So every IP comes with a legal liability, and if you try to misuse it, you may end up in trouble, right? Don't Google, don't rely entirely on Google for everything. Always try to consult, at least one professional, if not two or more. You could consider getting inputs from multiple people, but then at least try to talk to a few people just to understand how the process works and get some clarity. And don't do it yourself because, like I said, especially when it comes to trademarks, identifying classes, what subclasses, definitions, what you can use, the words you can use, cannot use, it plays a significant role, and it's very, very important. So with that, I would like to conclude my presentation and open up the floor for questions. Thank you.
Thank you very much, Harsh. This was pretty informative. I know you covered a lot of the things which have been requested in the chat box. I'm just scrolling up. I think well, can you read the chat box, Harsh? I think it's better if
yeah, I'll just
from
try to answer. Right. Voice is taking. How service could be registered? Yeah, you can get in touch with me. I can advise you on how it can be registered. Good to give some examples of each type. I think I've covered a few examples during my presentation. Kindly share each with an example. Okay. Can person file trademark for a process? And the answer to that is no. You can file a patent for that. When it comes to processes, products, anything that involves functional steps, technical aspects, you could file a patent for that. Right?
But Harsh, if I can extend that question a bit further. So let's say if you want to market your product using that specific process, that's where probably a trademark can come in handy.
See, process. So like I said, if that process can spin out as a product by itself or a service by itself, then we could consider filing a trademark for it. But then if it is not a service or neither a service nor a product and just process steps, right? Let's say there are functional or operational steps. associated with some kind of, let's say, a transaction, for example, then those process steps may not be trademark. But then if you can bundle it as a service and come up with a name or come up with a brand, then that can be trademark.
Thank you. I think that helps, because a lot of startups, are like, hey, I want to market this particular thing as one offering.
Right.
So that would be the service offering that you're suggesting.
Right. That would qualify under service mark.
Sure.
Do these corporations need to proactively scan for each trademark journal? You need not scan it. There are law firms or boutiques which are offering these services for you. So you could consider subscribing, where they will keep scanning the journals and update you if they find something similar or identical.
Harsh, the previous question to that was, I think you have almost answered it, but do organizations get notified when a mark similar identical to their registered mark gets advertised and is open for opposition?
Right. Yeah. When it is opposed, you will get a notification. So whatever proceedings are initiated at the IP office, you will get a notification. You will receive update on it, a detailed document. So normally the opposition is initiated with a form, and then there will be a detailed document as to why that particular mark has been opposed. So you will receive communication on all of it. Yeah.
But Harsh, I mean, I think the person wants to ask that, if let us say I have a trademark, let's say like Ola, and somebody registers Ola in a separate class, then they don't get notification. Your answer is that they should hire a law firm who will scan the trademark, the trademark publication, right?
Correct. Yes. The trademark office won't notify for identical marks. So you will need to hire a firm who will provide that kind of service, where they are scanning the journals on timely basis, and then they will provide you an update. Only if it is opposed, you will get a notification from the trademark office. Okay, now they're instructing the 2010 to be removed. Please guide. I'll need to take a look at it. If you can share, if you can connect offline and share the case details, I'll take a look and advise you on it. That established 210 is there, right?
Harsh, there is a previous question by Mr. Neeraj Goel. He's talking about a trademark, but the registry has refused it, and we filed a case in court on hearing. Authority says to file a fresh application for trademark, but in the decision they refuse it. What should we do? We are now a good known brand in our area. Please suggest.
Okay, I'll need to know the details as to why the application was refused, because without that, it is very difficult for me to advise. If so, I'll need to take a look at the case history, the files, if there was objection issued by the trademark office, and what were the objections. So we'll need to investigate the details, and then I can advise you further on it. Is it a nickname can be used for trademark? Example, HSR. You can use it, but then I don't know. I mean, it depends on the examiner. If he's familiar with HSR, what HSR is, or if HSR relates to an area of a place, he may not allow it. So yeah, it's very subjective. How to register the trademark for one's YouTube channel? YouTube's channel, if you have a unique brand for it, you can register. The content on YouTube itself, whatever content you're going to create and upload on the YouTube channel, it can't be trademarked, it can be copyrighted. So any form of expression, right, digital content that you create, you can copyright it. And by default, when you create the content, you are the original copyright holder. You need not explicitly register it. you can registration is only required if you think the content is very unique. But then again, if your channel is contains content which can be used to teach someone, right? Which can be used for, so it would qualify under the clause of fair use. So even if you copyrighted that content and somebody used it without your permission and you filed a case against them, it would not be valid, because if they are able to justify or prove that they had used the content for instructional purpose or for teaching purpose, right? So there is a fair use clause in the copyright law. So that would kick in and automatically your lawsuit would be dismissed, right?
Just asking here, because
Yeah.
I think many of our attendees may be from the social media.
Right.
So, for example, like, I mean, not just YouTube, let's say, you have a very unique social media handle or YouTube handle, and then, somebody actually duplicates it. And, so maybe this is the question. So would you like to talk a little bit more about this, of trademarking?
So duplicate in the sense, see, there are two scenarios. One is duplicating the content itself. Second is duplicating the brand. Let's say your YouTube, you have become a brand, right? Your name has become a brand. You could consider registering a trademark with your name. Again, it is subjective. They may allow it or not allow it, right? On a case-to-case basis, that would vary. But when it comes to content can be copyrighted, like I said, but then the copyright law is very, very loosely defined. Mm-hmm. So what we have experienced in the past is the moment you modify the content, let's say you have created the content, I take it and I add some of my own content into it. And even if you hold an original copyright registration against it, you will not be able to come and enforce it, because I have added my own content into it and I will have my own copyright protection against it. So the line is very, very thin, and on a case-to-case basis, it has to be evaluated. So there is no law in the stone which says, okay, even if 70% of the content is similar, it has been copied. So they will not conclude on that basis. So it's very, very subjective, and like I said, on a case-to-case basis, detailed investigation has to be done, and then they will take a call. Yeah, can we apply in application of a trademark in Hindi and English? Yes, you can apply, but then sometimes the trademark office asks for a description in English. So generally advisable to file it in English. If it is in Hindi, you need to file a translation and the related description as well. Training course.
Please don't mind. There are some questions relating to logo, and maybe you could take it up. Like, in case of applying for logo, does it include the word also? And what is the difference between logo or trademark?
Right. Logo, see, logo can be registered as a trademark. Logos can include words also. So for example, classic example is Nokia, right? Nokia has Nokia connecting people. Connecting people are words, expressions, and Nokia is a single word, a brand by itself. And then you can register this Nokia connecting people as a logo. Mm-hmm. So it has words as well as an expression, and it can be registered as a logo. So all those permutations, combinations are possible. But then when you're using an expression, it should be restricted to 3 or 4 words. Anything more than that would be constituted as descriptive, and the trademark office may object it.
Or Harsh, would you also consider like the Nike, just do it with the swoosh symbol? That is also a logo with words that would.
Correct. Yes. Yeah. Any symbol and word combination is permitted. So if you look at my logo itself, right, IP5, it says safeguard your brainchild. right? It has a logo, it has words, and then it has an expression. It has all three. So it was allowed last year. I got it registered successfully.
Oh, wonderful.
Yeah. So yeah, you
And
can use those
somebody's
combinations.
Yeah, somebody is asking the difference between logo or trademark.
Yeah, trademark is, see, whatever name or logo that you use, right? That can be filed as a trademark. Trademark is nothing but your brand, right? Trademark is a type of IP which uniquely identifies your service or product or brand. So difference is you can register your logo as a trademark, right?
And how should we extend that discussion a bit deeper? Because this sometimes comes from startups and even small businesses. Like, what is better to have, that word mark or logo? Because I think that word mark gives them the maximum flexibility. But if
Correct,
it's a logo,
correct.
it allows it to be written only in that specific format, right? Like that gives them that differentiating aspect.
Correct, correct. Yeah, it's a very good question. I would suggest if you have the budget, better to file and protect both of them, the word as well as the logo, because both have to be filed as separate applications. And let's say your brand qualifies or spans over 3 classes. So your class fees adds up. Your separate applications have to be filed, and that adds up. And let's say if they get objected during the examination process, so each application would be treated separately, and you need to respond to each application. So all of that adds up to the cost. If you have the budget, generally advisable to file both, right? Word mark as well as logo. But currently, what we have experienced is the chances of getting a logo granted, right? Even if it's a word mark, but if it is filed as a logo, chances of it getting granted is better. So generally, we advise to proceed with filing a logo. Even after searching for trademark availability via registrar oppose. It's a procedural thing, and this opposition is not filed by the trademark office. Opposition is actually filed by the third parties or somebody else who owns the trademark or has interest in that specific trademark. So only the trademark office only objects. They will object under certain sections. They will cite certain sections and then provide an objection and reasoning as to why it cannot be allowed. Does the font of the word or color combination play any role in trademark registration? Yes, it can play importance, but generally, let's say if you are looking to color your logo, generally we advise you to file the logos in black and white because you can change the color later on. Black and white is advisable, but if you are looking to file specific color logos, you can do that also. Whether we have to take NOC from anyone before applying for trademark? No, you don't need to take a NOC. But then if something similar exists, similar brand name exists, and you want to use the same brand name, one option which I wouldn't recommend, one option that you have is you could consider licensing the trademark from them, but then the original trademark would be registered in different classes and would have different subclass definitions, and if they are not related to what you're doing, licensing or paying them a royalty would be a waste of time and money. Just to keep the brand intact. Which databases? Yeah, Indian, there is a free database, but then, like I said, unless you know the classes, you will not be able to search. Unfortunately, that is the constraint or let's say feature of the Indian trademark database, wherein you are required to know the class for searching. So if let's say the trademark is filed in multiple classes, you will not know that also unless you know that they are in those businesses, and you'll have to individually go and search in those specific classes. Government of TN granting subsidy. Yes, there is from MSME there is a reimbursement. So if once your trademark is registered and you get a registration certificate, they will reimburse 10,000 rupees for every granted trademark application. So this is applicable at a national level, not restricted to any specific state. So you could considering getting a reimbursement. Is it possible to buy the trademark? Yes. Yeah, trademark licensing, sale, all of that is possible. You can transfer the ownership. Like any other type of IP, both options are available. You could consider licensing it or also buying it out. That is also possible.
Harsh, please do type out your email and contact details. There are people who want to consult with you.
Yeah, we'll do that. Okay, let me go back to the questions. Sir, is it association of be done with registered trade? Association of trademark. Yeah, if you need to enforce your rights, then registering would be recommended. You could consider, I mean, you can continue using it without registration, but then if there is an identical brand that comes up providing an identical product or a service, and if you are not able to justify why you were not able to register and all that, they may have a early more advantage. So if they go ahead and register, they may be able to secure those rights. What procedures for trademark registration of paintings? Paintings, no, it comes under copyright. So any expressions, right? Poems, cartoons, paintings, all of that comes under copyright law. You cannot trademark it. Logo of your channel, yes, you can register for a trademark. If it is a unique logo, you can. Source is not, when content is used, will it be considered as fair use? There is no requirement of acknowledgement, but then if the content is being used and let's say you hold a copyright to it and you get to know, right? Somebody is using it without your permission or without acknowledgement, and you go and try to enforce your rights, and that person is able to provide a justification that the content was used for teaching purpose, then that fair use clause would kick in. Are there trademark agents like Indian patent agent or patent agent authorized to perform activities related not only patent but all? There are trademark agents. Even lawyers can register as trademark agents without taking an exam. So that is how we operate. I am not a trademark agent, but we do have lawyers who work with us and help us with filing the trademarks. They help us with end-to-end support, be it search, filing, responding to objections and oppositions, and subsequent maintenance as well. Yeah, a full tagline is done to protect. Okay. Difference between patent, trademark, and copyright. So These are all different types of IPs. Patent is filed when you have a technical solution for a problem. So patent, again, there are two types. One is industrial design and one is utility patent. Utility patent is generally filed when there are functional or operational steps associated with your solution, technical solution. Design registrations are generally filed if you want to protect the look and feel aspects of an invention. So for example, the way your laptop looks or the form factor of your phone, the shape of a bottle, shape of a fridge, all these can be protected through design registrations. Trademark, we have been discussing about it for the past 1 hour. It protects your brand. Copyright protects expression. So any form of expression of idea, which can be in the form of poems, literature, art, paintings, digital content, cartoons, films, music, all of that can be copyrighted. University symbol comes under logo. Yes, it is a logo. How long shall we wait for the brand once opposition is going? There is this is not predictable because oppositions can go for typically 2 years or 2 to 3 years, sometimes 4 years also. Because what happens is there is a back and forth. The trademark office does a evaluation. They will come up with some kind of conclusion. You are again required to respond to that, and again it will go on record. They will again evaluate. So all of this will just add up to the time. Okay. If we have registered trademark in India, will it get no? We have discussed this point. So like any other type of IP, trademark also is a territorial or jurisdictional right. So wherever you register it, you get protection only in that country. But there is again a provision where you can make a single application, like how it is PCT applications for patents. So for trademarks, it's through Madrid protocol, you can make a single application and try to get protection outside India in each country. But then the timeline is restricted. So you have 6 months from the date of filing your first trademark application to complete filing. So if you miss the 6-month deadline, then you'll miss the priority date. Licensing and assignment of trademark. So example. So licensing is you can enter into an agreement with the original trademark holder, right? And you, let's say you're using, let's say you, the licensing term says that you're licensing it for 3 years and you're paying X amount for using the brand or the logo for 3 years. So that would qualify as licensing. In assignment, you would enter into a agreement, a contract, where a deed of assignment would be made to transfer the original rights. Whoever owns the trademark, let's say they want a fixed amount, you agree to that and you put all those details in the deed of assignment and register it with the trademark office and transfer your rights. So licensing can be perpetual. So once you transfer or assign the trademark, it's like a sale. You may not get it back. It's like a sale of good. Can smell be trademarked? Yes, I think it can be trademarked. I think the last session that we did with ASSOCHAM, we had a trademark examiner, and she did mention that smell can be trademarked. Although we have not dealt with any such cases yet. Association marks are applied by applicant in same class. That depends on, again, on a case-to-case basis, it depends. But generally, yes. If their service and business is in same line, it could be applied in the same class. Do lawyers need bar counsel license to act as trademark attorney? I am not quite sure about this. I don't think as long as you have a legitimate degree, I think you can write to the trademark office and check. They will be able to guide you on that. Minimum time to get registration of trademark, I told you it's 3 months. If it is very unique, something that will not attract opposition or objection, you can get it as quick as 3 months. Yeah, this can be done. I answered this. Can trademark be assigned or licensed? I've already answered this. Without goodwill, yes, trademark can be assigned without goodwill. It depends on a case-to-case basis. Without goodwill means you need to specify the terms. Why is it with goodwill and why is it not without goodwill? So, to whom to contact for registering logo? You can get in touch with me. I can help you with it. Yeah.
Not quite a rapid fire, but thank you, Harsh, for such a patient answering of every question.
No problem. Welcome. I'm hoping that all the queries are answered and people have learned something new.
I think the last question by Neha is probably that will indicate the significance of today's webinar. What happens if a trademark is not registered?
Yeah, if you don't register, you will not be able to enforce your rights. So let's say you have a trademark that you have not registered and your competitor comes in the market with identical product or service with the same brand. And if he moves to register before you, you will not be able to enforce your rights. Of course, there are provisions where you can prove that you were in business before him and all that, but then it's a very long drawn legal process. You will need to provide a lot of evidences to convince and then file the trademark application. So it will be a very long drawn legal process. So best is to start the process as soon as possible.
Okay, I think on that note we can conclude this webinar for today. Harsh, thank you so much for sharing your insights. As we all saw, right, you patiently answered every question by the participants. Thanks much for sharing your expertise with us today. To all the participants, I mean, it's great that you took time out this afternoon and stayed with us. These days the webinar overload is quite high. It's easy to be distracted, and yet you chose to protect your intellectual property. So it's a sign, which to me indicates, why India is on the rise, right? That it's not just the potential is there, but we are taking the steps to make sure that we safeguard our innovation. So thank you all the participants. And that's it from me, from the Qualcomm team and from the ASSOCHAM team. I thank my colleague Anirban for a wonderful moderation. My colleagues at ASSOCHAM for doing a beautiful job in organizing this and getting you all together. Wish you all a pleasant day. See you all later. Take care.
Thanks. Bye-bye.
Thanks, Harsh. Thank you so much. Thanks, everyone.
Thank you. Thank you.
Thank you.
Thanks.